Good morning. Yeah, that was a little bit weak. Good morning. Much better, much
There we
better.
go.
On behalf of my colleagues, Judges Reardon and Letica, welcome to the Michigan Court of Appeals. This is panel 3 in Detroit, the first day of our June case call. I'll make the usual announcements. We've read your briefs. We've had reports from our staff on all the cases we'll be hearing today, so we're very familiar with the facts. You don't have to belabor the facts. Just try to cut right to the most salient legal issues and let us know as succinctly as you can why you think you should prevail in your appeal today. In cases involving minor children or protected persons, please know full names, just initials only in those cases. These proceedings today are being digitally recorded and will be uploaded to YouTube within 24 hours. I think that covers it. So with that, I can call the first item of the day. These are consolidated cases, docket numbers 369401 and 376530. People of the State of Michigan versus Troy David Holder.
Morning, Your Honors. May it please this honorable court, Alona Sharon, on behalf of Mr. Holder, the defendant appellant. I will try to reserve 3 minutes for rebuttal.
Sure.
Judge Godola, heeding your words to try and be succinct, I do want to focus most of my attention on the sentencing issue in Mr. Holder's case.
Yeah, Judge Godola and I are familiar with this case. We had it once before.
Mr. Holder's case.
I think that might be later.
No, that's later. Excuse me. I'm sorry.
Not this
wrong
way.
one.
Oh,
The-
okay. I was
I'm
starting
sorry.
to think
I
I was
started
really
to have
missing
second,
something.
I started to question that, and then when I saw the look on your face, I thought, because there is one where
There is- you know
it's
what?
coming back, and we were both on it earlier.
Well, I'll have to say he's more familiar than I am. But no, I'm sorry.
That's
It
okay.
popped up on my iPad here the wrong. So
That's okay.
I'm
I
having
just
all
thought
kinds of electronic
maybe I had
issues
missed
this
something
morning.
really important.
No.
Okay, as it relates to sentencing, candidly, Your Honors, I cannot find another case in which something like this has ever occurred, where a prosecutor argues to the jury very specific facts and events to underlie each charged count to the jury, and then before sentencing, because if you review the prosecutor's sentencing memorandum in which she advocates for consecutive sentencing and scoring of OV11, does a complete 180, and everything she argued to the jury to convince them to convict on charges 1 through 8, counts 1 through 8, goes out the window, and instead different facts are used to underlie each count so that the prosecutor can then work to seek a harsher sentence for the defendant. I can only imagine that that's never happened because of how offensive it is to the system, Your Honor. And I would liken this issue to what this court has done in Beck and in Double Jeopardy with the rational jury approach, right? Is that you have specific facts, specific events that are presented to a jury on which they pass judgment, and that is what we are to consider. I fully acknowledge that it's not exactly on point, but it is the closest thing I can find to sort of mimic what happened in this case. This trial prosecutor very specifically outlined conduct for each count and now wants to say, you can't hold me to that if there's another scenario in which I can argue different facts and get a harsher sentence for this defendant. And what's problematic with that is threefold. First of all, right now, there are 3 different versions of events that underlie these 8 counts. There's the prosecutor's version at closing argument, the prosecutor's version in her sentencing memorandum and her argument at the motion for new trial, and then the third version is the trial court's version, which is different than the 2 prior versions.
Well, what was the jury charged with? I mean, isn't that really all that matters?
Well, Your Honor, they're charged with the 8 counts, right?
Right.
And the prosecutor very specific delineates what conduct underlies each count.
Right.
Okay. All right.
So aren't we then to presume that the jury convicted on the basis of the instructions that were given and which facts go with which count?
Right. I agree with that, I think, because
Okay.
what the prosecutor is arguing is that the prosecutor's argument to the jury is, who cares about it, right? Because they're instructed that it's not evidence. And I really think that that is a red herring argument, Your Honor, because those are the facts on which the prosecutor said to the jury, these are the acts that he committed that support the counts on which I am seeking a conviction. And
Your point then being that those facts as connected to those individual counts don't justify the scoring and the consecutive sentences.
right, and I
Yeah,
don't think
okay.
the prosecutor's office can test that. I think that's exactly why they had to change their narrative when it came to sentencing. Another fact that they don't dispute, right? They don't dispute that they have now absolutely changed the underlying facts for each count from what was argued. They concede that in their brief, that I am correct in that. Okay, and if you look at the way the prosecutor argued it in closing arguments, the consecutive sentences are illegal, as is the scoring of OV11 on all of the counts. And what's problematic with this practice is there were 23 incidents that this child testified to. How do we know what he was convicted on then? If we're going to take this position that after the conviction, the prosecutor can argue any one of these 23 incidents matches up with counts 1 through 8, how can they even meet a preponderance of the evidence standard? Because we have no idea of knowing then what the jury convicted on. They can just cherry pick 8 out of the 23 that gets them the harshest sentence. That's not justice. We need to know on what scoring of offense variables and imposition of discretionary consecutive sentences are fact intensive analyses. You have to know what is the underlying conduct in order to score OV11, 12, 13, 10, 9, any of the McGraw variables you would have to know. So this practice of arguing one set of facts and then saying, no, we're just going to change to something else that fits our purpose after conviction should not be tolerated by this court. Two other things I just want to briefly touch on. The report from Dr. McMorrow, right? So the prosecution submits in their brief that there were 2 strategic, and I air quotes, that this report was admitted or stipulated admission by defense counsel. And that was, 1, to get tests to put in front of the jury that the mother accompanied the child to this appointment, and 2, that the child refused the exam. Okay, the report was absolutely not needed to get that evidence in before the jury. The child testified, the mother testified, and Dr. McMorrow testified, admitting a report in which the child retells her allegations, and then there's a suspected diagnosis of child sexual abuse noted in the report multiple times, is not a strategic reason to admit the report where those same facts could easily have been introduced through all 3 witnesses. Finally, the hearsay statements, I really think the brief is very thorough on that. I'm not really going to touch on that. The genital piercing. In 20 years, I didn't think I'd have to talk about a genital piercing before this court. I'm not really going to touch on that either, other than the fact that I think the affidavits support that these women could have given favorable testimony for Mr. Holder. And finally, and I will talk about this for just a moment, the ineffective assistance for not bringing out in front of the jury the different motives that the complainant had to fabricate allegations against Mr. Holder. The prosecution argues that I failed to meet my factual predicate, but in the brief, I very clearly tell this court that I reviewed all of the forensic interviews, and is from those forensic interviews that I gained this material. And I drop in a footnote that that is one of the primary reasons that a Ginther hearing is needed, because the forensic interviews are not part of the trial court record. I never had possession of the forensic interviews. I had to go to the AG's office and sit for hours on 2 different days. So I can't provide it to the trial court. It's not in my possession. And that's in part what the Ginther hearing is needed. I can make an offer of proof, which I did. And that does meet the factual predicate, that there was information. All of these children were forensically interviewed, not just the complainant. And so I would hope trial counsel reviewed those interviews. And if he didn't, well, that's deficient. And if he did and didn't use this information, that's deficient. Your Honors, thank you very much. And I would save the rest of my time, unless the court, of course, has any questions.
No, sorry for interrupting you.
That's
I
okay,
was
Jeff.
referring to Appendix B. He cited a case that Judge Godola and I were on.
Oh,
So that's when it popped up. So my apologies.
Good morning, Your Honors. May it please the court, Nick Johnson, Assistant Attorney General, on behalf of the people. I also recognize Judge Godola's point. I will try to be brief and succinct. I'm also feeling a tad under the weather. It's no excuse, but I will try to get to the most salient points. With respect to the sentencing issue, the people's brief concedes that counts 2 and 6, that OV 11 and consecutive sentencing is not appropriate for those 2 counts. I think it's clear, given the victim's testimony and how those counts were read to the jury, Judge Godola, you noted that as well, is that it just simply can't be possible. The penetration that occurred in count 1, or rather, I'm sorry, the contact that occurred in count 6, the sexual touching there, there's no indication that the penetration would have rose out of that. So we concede that point. We recognize the record supports that, and the trial court's finding on those counts was erroneous. So we believe that count 6 should be scored for OV 11, scored at 0. And that results in a limited resentencing for that issue. If the court has any questions on it, I'd be happy to answer it. No. But I do just want to address the notion of trial counsel and how, the prosecution's theory had changed from closing argument to sentencing. I did have a chance to speak with the trial prosecutor. She recognizes her mistake. I think I'm not here to make excuses for anybody either, but it's a very fast-paced trial. It was very emotional. I think when you get on appeal, you kind of lose that element of the human element and how fast-paced things are, juggling.
Mistake with respect to which aspect? I don't know what you're talking about.
Well, just in terms of how fast when I spoke with the trial prosecutor, she indicated that as she was making notes, she was trying to record, as even counsel indicated, there was several incidences of abuse, and it was, there were 8 counts, but she tried to describe as many as she could. So recording those instances of abuse and trying to determine which ones would meet which counts, just that aspect and how fast paced things move in that scenario. So, but with respect to the legal issue before this court as well, as Judge Godola, you noted, prosecutor statements and arguments aren't evidence. The jury was repeatedly instructed on that. And with respect to the standard that is on the sentencing issue, it's the trial court making the factual findings by preponderance of the evidence, and it's supported by the record. And counts 1 and 5, it was clear that those penetration and contacts there's record support evidence that the counts 1 and 5 arose out of one another, and then counts 3 and 7 as well. So,
just say general rule is counsel's arguments aren't evidence.
I think we can presume that the jury is instructed that the jury is instructed that the prosecutor's statements during opening statements and closing arguments aren't evidence, that they're just how the prosecution believes the theory of their case is going, and then that the court and that the jury is rather supposed to decide the counts based on the evidence that's presented. So ultimately, that I guess that's right.
That there's representation to the jury that these are the facts that you are looking at to determine that.
Right, and I don't have any. I looked as well. I didn't see any case law on the specific issue as well. All I can note is that the standard of review in Gloucester, cited in the people's brief, is just simply when you're reviewing an OV 11 score, it's simply whether the trial court's findings of fact are supported by the record, and in this case, I think they are with respect to counts 1 and 5 and counts 3 and 7. As to the if there are any other questions on the sentencing issue, I think it's pretty well briefed.
So you think that OV 11 is properly scored with respect to those 2
counts? With respect to counts 5 and 7, the people would submit that OV 11 is properly scored. It was improperly scored as to count 6, and because reduction of 25 points would result in a change of guidelines, that resentencing is appropriate on that, as well as.
And the consecutive sentencing is supported in your view?
Not with respect to counts 2 and 6.
Right. But
yes,
what about the others?
With respect to counts 1 and 5, there is record support, I believe. So count 1 was CSC1, victim under 13, digital penetration. And then counts 5 was sexual contact, the defendant touching the victim. And that's supported by the record that the trial court noted in the resentencing. it's the eighth assault that the victim described in her testimony. In my brief, I go through, there's 10 specific incidences that she describes. Some include contact and penetration, some don't. But so, yeah, counts 1 and 5, it's the eighth assault, and that is recorded on trial pages 106, 107. And then with respect to counts 3 and 7, it's the victim between 13 and 15, and it's a digital penetration and then sexual contact, and it occurred when they're in the same household. She's between 13 and 15, and that would be the fourth assault that's described. So the record does support that for, yes. Just briefly on the ineffective assistance claims, the trial court, with respect to the report at issue, the trial court decided and actually rejected the prosecution's argument that there were strategic reasons for admitting this. It decided solely on the basis that the report was admissible under the medical exception to the hearsay rule. So while there arguably there were strategic reasons, the trial court ultimately determined that the report was admissible as under 803.4, and that any objection to it would have been futile.
Any hearsay objection.
Correct. Yeah, any hearsay objection. And then, in terms of the vouching issue as well, people's brief explains why this case is different from Harbison. It does say McMorrow's report indicates there was a primary diagnosis of suspected child abuse. It was the initial encounter. I think when you're reviewing that, it's very different from Harbison, which the doctor in that case said it was the diagnosis essentially was probable child sexual abuse. It's very different from suspected initial encounter. And here, I think the context of the entire statement makes it clear that really it was just indicating and recording what the purpose of the visit was initially, the initial going to the examination, and not so much actually providing a diagnosis. And ultimately, her testimony as well, she didn't opine on the credibility of the victim and really just set forth the process for medical examination and the delayed disclosure, and that was permissible under Peterson. So in terms of the last issue, in terms of the other issue with respect to the genital piercing, I think it's very clear that counsel reserved his opening statement, did not make it right after, and then decided that after he pressed the victim on what his genitalia had felt like, it was very strategic that defense counsel wanted to make this an ambush tactic, that wanted to reserve the opening statement, lay out that that the victim's description of it was different than obviously what it was. And so I think there are clear strategic reasons for why not calling these witnesses to corroborate his own testimony. If there are any other questions, I'd be happy to try to answer. Otherwise, I'll just rely on our brief for that.
I think we're all set. Thank you.
Thank you.
Counsel?
Yeah.
Mhm.
Just briefly, I think that the prosecution somewhat misrepresents how many times this reference to suspected child sexual abuse is notated in Dr. McMorrow's report. If you look at page 28 of my brief, and of course the report, a redacted version of the report of sensitive information was provided to the court as well in the appendices, but there's a primary diagnosis of suspected child sexual abuse. There's obviously the details of AT's disclosure. And then there's another section under assessment and plan where the descriptor, quote, suspected child sexual abuse is noted a second time. And then a third time under the visit diagnoses, the diagnosis of suspected child sexual abuse. So it's not just one time where there's this initial notation, it's several times throughout the report. Your Honors, if there are, Judge Letica, you asked, how are we supposed to know what incidents we're talking about? And prosecution again responds with, well, the jurors are told that the arguments are not evidence. This court has found in other cases that there are some instances where that instruction is just insufficient, right? It can't correct an error. And here I think where you have a prosecutor who is very clearly delineating 8 specific events for 8 specific counts, an instruction to them that the argument is not evidence is not a way to remedy this problem. Okay, the way to remedy this problem is to hold the prosecution to the events that they say underlie each count, and that the scoring of the guidelines and the legality of a discretionary consecutive sentence must be determined based on those events alleged by the prosecution. And finally, if this court or the trial court has no idea which of these 23 incidents underlies the 8 counts, you you can't meet the preponderance of the evidence standard. It's a guessing game. You're just cherry picking at that point, and it can't meet the appropriate standard, Your Honor. Thank you very much. I ask that the court vacate the convictions on the claim of ineffective assistance of counsel, or in the alternative, find that the sentences are illegal and remand for resentencing. Thank you, Your Honors.
Very good.
Thank you.
Thank you. Appreciate your arguments here today and for appearing and here in person today. Appreciate it. And the cases are submitted. That brings us to item 2, docket number 373848, People of the State of Michigan versus Rodney Damon Black.
Bill, on behalf of Mr. Black.
You may proceed.
Okay. Primarily, I'd rely on my brief. This was third Miller resentencing. And the prosecutor and the court seemed to think that I thought that the divorce situation was controlling on whether he should be resentenced. The reason I brought that up was because the judge seemed to have misunderstood it when she sentenced him to 39 to 60. And that's why I thought it was important to give that information to the court. It was in the 2017 sentencing memorandum, the huge sentencing memorandum Ms. Newman prepared. And I provided that to the court as well, because when I asked the Wayne County clerk for the file, I didn't get it. So I didn't know if it was part of the file and whether this judge had seen it, because she was not the sentencing judge in 2017. And it really laid out that he did have a difficult childhood starting from the divorce on. And that's about it.
Any questions for counsel?
I just had a procedural question. Is this sentencing, or is it one that had to be brought under 65?
That was an error the judge made, I think, in her opinion.
I was just wondering, because I kept saying, why is he calling it? Why is the judge calling it a 6,500?
It's a Miller resentencing.
Yeah.
Yeah, and the other error I think
Okay,
that
thanks
she
for
made.
clearing that up. I'm glad I wasn't losing.
The other error she made was on page 3, when she said that she could sentence any number of years between 25 and 45. It's 25 to 40. So, if she really thought that, maybe she thought that he was farther down in the range than he actually was. So.
Okay, anything else? All right, thank you. You'll have time for rebuttal should you need it.
Good morning, and may it please this honorable court. My name is Madison Leonard. I represent the people of the state of Michigan. I'm just going to be very brief. I know
Right.
that you all have reviewed our filings. This is not a complicated case. I think it's very clear from the record that the trial court on defendant's second, I believe he was sentenced and then he was resentenced one time under Miller to
40 to 60.
40 to 60, yes. And then resentenced a second time now to 39 to 60. The trial court made very clear in this second resentencing that she had reviewed the sentencing memorandum that was provided by the defense counsel. She had access to it, that she considered it when she was evaluating all of the Miller factors, and that she considered them as mitigating factors of defendant's youth, and that his age very likely impacted his decision-making when he chose to commit the homicide. That's the underlying offense in this case. Those factors of his youth were acknowledged, and the court chose to take his sentence down from 40 to 60 to 39 to 60, even though she was not required to. She put all of her considerations of his youth on the record before resentencing him a second time. I do not believe the facts and the law support a third resentencing in this case. Therefore, we would ask the court to deny defendant's motion.
Any questions for council?
No, but I want to thank council for coming because typically Wayne County is not here for.
I've heard we've been described as a unicorn, so I'm very glad to be here.
Yes. We're all
Well,
glad you're here.
We all appreciate
Appreciate it.
timely briefs and appearances in case we do have any questions.
Of course, thank you, Your Honor.
Ms. Somerville, any rebuttal?
Just briefly. In 2017 was the big, very thorough sentencing memo.
Yes.
There was a different sentencing memo submitted in 23, so I don't know that the judge was aware of the 2017 memo. And at page 31 of the 23 resentencing, she describes that she doesn't consider his family situation a mitigating factor. And those are the only.
She's not required to, is she?
Well, she wasn't viewing it.
She's required to recognize his youth as a mitigating factor, but not the fact that he had a difficult home life.
that his
The
whole
judge
life-
might well do that, but isn't required to do it, as you seem to suggest.
Well, it's part of his youth, right? He was in a wonderful family situation until the divorce. Then things fell apart. And when he was at each parent's house, he was couch surfing because he didn't have a bedroom. He was out on the street. He essentially wasn't even living with either of them at the time of the offense.
Right, but it sounded to me like they were trying to get him on the right path, which is, I think, what the judge was commenting on and trying to get him help, and it didn't work.
Yes, they did try to get him into counseling. And apparently it didn't work, but he's been doing very well since then, and I did submit his most recent
I mean,
things that he got in prison.
I think the judge did consider it, and unfortunately, the circumstances here, as you know, are very serious. I mean,
Very.
he shot the mother, he killed the 3-year-old and shot the 5-year-old, and the 5-year-old ultimately died from the injuries when he was an adult. So you have 2 dead people in a horrible situation.
Aren't all murders a horrible
Yes, they
situation?
are.
Thank you.
Thank you. The case is submitted. That brings us to item 3, docket number 369684, People of the State of Michigan versus Ronald Charles Getz.
Please the court, Ashley Siegel for appellant Ronald Gates. I first want to point out that in Appellee's brief, they do the same thing that I'm complaining of here. Is the only thing that they point out are the facts that were given at the trial by the complaining witness who wasn't subjected to any meaningful cross-examination. And I think it's telling that Appellee's brief also did not dispute the facts that I put in my brief, that my office went to great lengths to try to summarize for the trial court and this court in 2 different forms and fashions to really point out that there were 4 distinct stories that this complaining witness told, each having material, serious.
But there were consistencies as well, weren't there?
Not anything appreciable. I mean, the only consistency was that that he says that he was, molested,
Age 11,
raped by his.
Age 11, molested. I mean, that was consistent all the way through.
I suppose that was. But even at the preliminary examination, after he had been told 2 different police officers that there was oral sex involved at the preliminary examination, He said, no, oral sex was never involved. And, you know, the attorneys even said, do you know what oral sex is? Are you sure? And he said, yep, never happened. And then at trial says it happened again. Um, and we're not standing here today as really the triers of fact. There was only one defense in this case, was that because there was only one bit of evidence. The only evidence was the complaining witness's testimony. There was no physical evidence, no corroborating witnesses. Even a couple of the corroborating facts that the appellee points out isn't indicative of a sexual assault. It says, oh, he knew that he had a gun, or he knew that he drove a certain kind of car. Well, he was a stepson, so he would know about what items he owned. But the only evidence was this complaining witness's testimony. And also, the record is very clear. It speaks for itself here. First chair said, if I had to cross-examine the only piece of evidence against my client, I would be ineffective assistance of counsel. I can't do it. And, second chair has prepared for months for this. Second chair took his duty to defend his client so seriously that he was not in the courtroom during the complaining witness's testimony. He left the courtroom and had to ask the court for an entire day, to adjourn the whole trial for an entire day so that he could go home and prepare overnight. Now, they ultimately agreed to let him review audio recording and prepare that way, but it just shows how seriously he took his job. Also, the transcripts show too, the first 75-80% of his cross-examination, he sounds like the prosecutor. He's like, you told the prosecutor this, right? You told the prosecutor, you said this, right? You said this, you said that. Just reaffirming and strengthening the case against his client. It wasn't until the end where he kind of seems to have thought, oh, maybe I should do something here, and mentioned one very small inconsistency about him being tied up by the ankle or not. So I would say that, this record speaks for itself. However, I did request a Ginther hearing, and I still, if this court isn't inclined to vacate the sentence based on the ineffective assistance of counsel, I still would like a Ginther hearing so that the attorneys could speak for themselves. We get, whenever appellants in this case, these kind of cases, ask for the court to find ineffective assistance of counsel, we get accused of using the benefit of hindsight and armchair quarterbacking. Well, that's what FLE does here too. They say, oh, well, maybe he wanted to treat the complaining witness gingerly. Again, remember, the complaining witness is a grown adult man at this point, so it's not like a child. And also, I can see that if there was various forms of evidence and various strategies for defense, maybe you would choose to treat a child gingerly, a sensitive witness. But this is your only shot. This is your only defense, and it's a good defense. It's a strong defense. How could the jury possibly make this decision without knowing the facts and knowing that this witness has told a different story every single time he's told this story? The fact that trial counsel wasn't prepared and the fact that they didn't meaningful cross-exam is inexcusable in this case and seriously undermines the integrity of the conviction. Just real briefly on the issue of the PSI, everything in the PSI was taken from the second police report, everything, and not from the first police report, not from the preliminary, not from the trial. And there's just no real excuse for that. The trial court should find by a preponderance of the evidence that the PSI is accurate. Actually, Appellee's brief in this case on page 19 is my best argument here, is that the PSI not only needs to be correct for purposes of sentencing, but also because it follows them into MDOC, affects their programming, and needs to be accurate for that reason as well.
If we remanded, how would we tell the trial court or that the PSIR should be corrected? What do you suggest? Go back to the police reports?
That we would get a chance to argue maybe the prosecutor and the defense attorney could get together and come up with a stipulated narrative. Or maybe we could just argue the facts and the judge could make a finding of, I'm going to have this version in the PSI report. Also, what I would argue is have it be in the PSI report that there were inconsistencies, that he said this at one time, but he said this at one time, but he said this at one time. I think that would be the fairest way, especially the two pieces of testimony that were under oath.
So the Department of Corrections prepares who prepares the PSIR?
Yeah, Department of Corrections, employee parole.
We'd be really, I guess, cutting some new ground, asking them to bring the parties in to argue which should be included, correct?
I don't think so. I've corrected the narrative, the agent's description of the offense by stipulation before and by argument of having a trial court say, yeah, I don't find that that's supported by the evidence, or I don't find that that's supported by a preponderance of the evidence. We're going to strike that. Or like I said, also by stipulation. Trial counsel didn't even attempt in this case. And as I said in my brief, it's completely appropriate for me to bring that up at the first time for appeal. And I did that and was denied. Does the court have any other questions for me?
Any other questions?
Thank you, Your Honors.
No.
Good morning, and may it please the court. Assistant Attorney General Daniel Kelly on behalf of the people. This appeal ultimately comes down to two questions. First, did trial defense counsel perform deficiently under the highly deferential standard for strategic decision-making in cross-examination? And even so, is there any reasonable probability of a different outcome in this case where the core facts were consistent, corroborated, and supported by some of the defendant's own admissions? Now, the record shows the answer to both of these questions is no. Let me begin with the ineffective assistance claim. The appellant frames this as a case where counsel was unprepared, but the record shows otherwise. The attorney who actually conducted the cross-examination, Mr. Nightingale, had, by defense counsel's own representation, prepared for months after a recess that exceeded his request. He affirmatively stated he had reviewed the full direct examination and was ready to proceed. And the courts have long held that we evaluate counsel's performance based on what they actually did. What counsel did here falls squarely within a recognized reasonable trial strategy. The victim was fragile. He had documented trauma, mental health struggles, and substance abuse issues. In cross-examination of such a witness, including the choice to avoid appearing aggressive or avoid inflaming the jury, is inherently strategic and reasonable.
What about the failure to point out the inconsistencies in the testimony?
Well, Your Honor, I do believe one inconsistency we have already identified being tied up was pointed out. Whether or not it was reasonable to go after every other inconsistency, including those in trial testimony or previous preliminary
About
examination.
the fact of what the sexual assault involved?
Well, it was consistent all the way through, Your Honor, for the 11 years old, the penetration and the way that it occurred and who did it, that was consistent all the way through.
Well, yeah, I understand that, but what about, did oral sex occur? Yes, no, yes.
Correct. That was an inconsistency. I think it was twice during.
Seems like a big inconsistency as compared to the one that was asked.
That is true. And I can't get into counsel's head, and I can only speculate as to why he chose to ask the questions he did. But I have to say we have to defer to the counsel generally on issues of strategy, especially questioning, as I mentioned, a fragile individual who the jury had already seen had made some inconsistent statements, who had seen his mental health struggles, had understood his substance abuse, was aware of his own criminal history. I mean, there's quite a bit there for the counsel to argue in closing about reasons not to believe him, including, the indicating actually he is a victim. This did occur. We're just saying it happened by somebody else's hand or somebody else was the perpetrator. And to continue to push that narrative, every single inconsistency was not necessary to make that argument. And then turning briefly to the PSIR issue, the appellant identifies no specific inaccurate fact, no proposed correction, and no explanation of how anything affected the sentence. The defendant received the mandatory minimum, thus any uncorrected or immaterial discrepancy should be viewed as harmless. For all these reasons, the people respectfully request this court affirm the convictions and sentence and deny the request for remand, but I'm happy to answer any further questions this court may have.
Any questions for counsel?
Thank you, Your Honors.
Any rebuttal?
Eppley said that the attorney Nightingale admitted that, or said on the record that he had prepared for months. No, first chair said, oh, my co-counsel has prepared for months. So we don't have enough that on the record.
Well, one of your client's lawyers represented that to the court. So,
One of the process, right,
What-
defense attorney.
right,
Yes,
yeah,
defense,
co-counsel told the court
yes,
he's
exactly.
prepared for months. I
So
think we
it-
have to presume he's not lying to the court when he says that.
Well, whether he would know what his subordinate is whether he's
I
preparing or
would
not.
think so, because he told the court that. If he didn't know, he wouldn't have said anything. He told the court, my co-counsel has prepared for months. I think we have to take that
You're
at face
right.
value.
I agree with your honor
Yeah.
that, of course, if he represented that to the court as an officer of the court, he probably had a good basis for saying that. Or believing that. Twice, Eppley pointed out or described the witness as fragile. The witness was a criminal and a drug addict and had, during the pendency of this, broken into somebody's house with a father and a son, a stranger's house. Horrifying.
You remind me how old he was by the time of trial? Roughly. Okay,
I'm guessing. I mean, I'm not guessing, but like
Right.
22, 20.
we'll both take a look at that.
Thank you. Lastly, reasonable probability of a different outcome. I just want to point that out again, since Eppley brought it up again. Yeah, reasonable probability, the jury has to find beyond a reasonable doubt. Impeaching a witness based on credibility is a reasonable doubt. So I'll just,
Didn't your client make a statement to the police that he lies at times?
that my client lies.
Yeah,
There was an interrogation video, and I did point.
he would lie at times to protect himself. So the jury's judging credibility, isn't it?
Well, my client didn't testify, so I don't know that that would really be
Yeah, but that would get into the record.
possibly, but I don't think any of my client's own words were really used against him. The only words that were used against him was this crazy interrogation video that I watched that the interrogator leads him into, well, you could get out of this if you say, like, give us a different explanation. And maybe you were wearing basketball shorts and maybe they slipped down when you were getting them out of the bath. Anyways, the point is that
I
my
mean, he
client.
said there was a 50-50 chance, or he told the detective there's a 50-50 chance that something could have happened.
Yes, and of course, now we're saying this when he was 4 years old. So that's not an admission of any of the pertinent facts in the case. And it was not an admission, but it was used against him in the closing. It was used against him in the prosecutor's closing, which I think was unfair.
Okay, anything else for us?
No, your honors, thank you.
All right. Thank you. Case is submitted. All right, item 4, docket number 371070, Samuel Belogan versus City of Detroit.
Morning, Your Honors. Zach Runyon on behalf of plaintiff appellant Samuel Belogan. This case comes to the court upon the Wayne County Circuit Court dismissing my client's claims on a motion pursuant to 2.116C10. I know the court is familiar with the facts, so I won't belabor them too much, but I think the appeal raises some important legal issues for how the Elliott Larson Civil Rights Act is applied. First, with respect to the discrimination claim, the court essentially dismissed my client's claims because she said that Officer Stribling, Officer Hampton, and Officer Denmark were not similarly situated employees. And her basis for saying that was that my
No, they
client,
were under investigation, were they?
they were not under investigation. And I think that's what makes this case important, is because that's not a relevant aspect of the truthfulness in an investigation. And we have that both in the DPD policies and through Davidson, who was the investigator's testimony in this case. He said, whether you're the person being investigated or you're just a witness, you have the same duty of truthfulness. And so if the duty of truthfulness is the same, whether or not you're the individual being investigated, that's not a relevant difference in the employment. And we have several examples of all of the witnesses in this investigation making contradictory statements.
There was lie upon lie, or
It was
he lied, she lied.
Exactly. And the whole investigation was actually started based on a lie. Officer Stribling accused my client of choking her.
Oh, she was consistent about he grabbed her neck.
Well, she actually wasn't. If you look at what she told the
What did
arbitrator.
she say? Early in the morning, choke him, and then said, well, he had his hands up around my neck later in the day. she changed?
So she initially said he choked me. Later that day, she said he was just joking around. He wasn't trying to hurt me.
Right.
She ended up writing a written withdrawal of the complaint against my client during the investigation. And then during the arbitration on my client's grievance, she told the arbitrator that he just grabbed me around the shirt. And the arbitrator actually made note of that and said, you know, I don't know how you could confuse choking with grabbing somebody around the chest area. And I think what's important is the investigator also stated that if Stribling had said from the very beginning that Belogan had just grabbed my neck and wasn't trying to hurt me, they would have never launched an investigation, that it would have just been handled at the precinct level. It wouldn't have been an internal affairs issue. So the investigation should have never been launched in the first place.
But it was.
It was.
So then what?
So then what is that if they applied these standards equally between all the employees, either nobody should have been investigated for making untruthful statements or they all should have been, because they all have the same duty of truthfulness. They all gave conflicting statements. Stribling actually admitted through a written document that she didn't tell the truth about saying that my client physically assaulted her by choking her. In Hampton, who was the one who reported the incident to IA, stated in this case that, yeah, Stribling lied to me about what happened, and she lied about Belogan choking her. And so, you know, if they wanted to apply this fairly, everybody should have been investigated. The fact they weren't is disparate treatment in itself. I think another important aspect of this is the investigator said throughout the entire time he's been investigating internal affairs investigations, this is the only time they substantiated untruthful statements based on, you know, he said, she said evidence.
We're talking about a significant time frame. We're talking about 2 years where you're alleging the lies took place 2 years after the incident.
No, the internal affairs investigation started within a week of the incident.
No, that happened, but Sergeant Hampton and Sergeant Denmark and Hampton or Stribling, they gave deposition testimony a couple years after. Is that correct?
That's correct, but they gave their interviews were, so there was several statements they gave related to this case.
Right, and you were comparing statements right after to statements that are a couple of years after, correct?
Well, not always. In some of the instances, yes, but so at the department level, they gave an interview the night of the incident. They later gave a Garrity statement, which was, if I'm remembering, it was about 6 months to a year later. There was conflicting statements in those as well. But yes, as far as comparing the deposition testimony to what was said during the interviews, that, you know, there was a few years in between those.
Recollections change over time, don't they?
Sure, but I think what's important is that each of them during the contemporaneous interviews they gave were making completely contradictory statements. I mean, Stribling and Hampton said that Hampton said that Denmark was a witness to Stribling saying my client choked her. And Denmark from the very start says, I was never there. I never heard any of this.
You know, it seems to me that you wish to characterize every instance of an inconsistent statement as a lie, or someone saying that another witness lied to me means that the other witness lied. I mean, that other witness didn't say, yeah, I lied, but someone characterized what they said as a lie. I'm not sure we can take at face value that everybody in this is a liar just because they recalled this differently at different times during the course of the investigation and then this litigation, or that they're a liar because someone else calls them a liar.
But that's exactly what they did to my client. I think that's the important thing. That's exactly why they investigated my client, is because somebody said something inconsistent with what he did.
Right. I mean, he's the one under investigation. So they started the internal affairs investigation, which to my understanding, once they start one, they can't just call it off. They have to complete it, is my understanding of the record. So he's being investigated. I understand your point that, well, why weren't these other people investigated? They weren't. And the investigation came to a conclusion that was not favorable to your client. So, you know, it's like what we do here or a trial judge does. You have a record and you have inconsistent statements quite often, and you have to resolve those in favor of one side or the other. So,
Right, but if you look at, and I think the Moore versus Huntington Bank case is really kind of important, and so is the Heck case out of Michigan Supreme Court. And they say that, you know, like if we just accept that, you know, Belogan made an untruthful statement, and the policy allowed the Detroit Police Department to fire him, you could still have a disparate treatment claim if you can show that that policy was not applied equally.
I understand.
And
Yeah.
so I understand what you're saying, that, you know, the investigation didn't go his way, but even if you take away the fact that the others weren't investigated, this was the only time the investigator could ever remember that they substantiated an untruthful statement claim based on he said, she said evidence, which they never had any documentary evidence to say my client was lying. And he said most or every other time he can remember disciplining somebody for an untruthful statement.
Well, the untruthfulness had to do with, correct me if I'm wrong, whether or not he was alone with the stripling, I think is the complaining witness, if you will. Whether or not he was alone with her. And I think it was substantiated that he said an untruth about that aspect of it. So we spent a lot of time talking about whether Stribling was choked or just touched. But that wasn't ultimately the reason for the termination. It was because of the untruthfulness. Is that correct?
I'd say it's halfway correct. So the Detroit Police Department actually terminated my client for 6 different reasons. And then it went to arbitration, and the arbitrator said that 5 of the 6 were unfounded and there was no basis to terminate. The arbitrator did say, based on a statement my client made at the arbitration, where my client said, well, I guess I was alone with Stribling for 10 seconds. And he said, you know, I didn't understand that they meant, because what happened is Stribling and my client were in the room with Denmark and Hampton. And Denmark and Hampton left the room first because they were closer to the door, and my client followed them out the door. So at the arbitration, on advice of his counsel, the union counsel, he said, well, I guess if we're being very, very specific about it, I was alone with her because I was following the other 2 individuals outside of the office. And, you know, the way my client understood the questions during the investigation was, were you interacting and with Stribling for a, you know, an appreciable amount of time alone in that room? And that's why he always said, no, I wasn't. But as far as the actions taken by the DPD, I don't think that's actually relevant, because the only basis the arbitrator had for substantiating that claim was things that my client said during the arbitration. And, you know, if we could go back and my client could maybe be more clear about that during the arbitration, he probably wouldn't be fired. But I don't think the DPD can, you know, take something that was said after they decided to fire him and say, well, now we can use this as the reason to fire him, because they didn't have that basis at the time they made their decision.
Okay, understood.
And so there's some, I think some other important issues I wanted to touch on. The hostile work environment claim, you know, there was significant evidence from every witness that we deposed that my client was frequently mocked because of his ancestry. He was, you know, they were always mocking his accent. One of his supervisors called him Mandingo, which is a reference to a movie about the slave trade. Many officers would say he should use a blowgun, which is like a blow arrow, you know, that's associated with undeveloped African countries. And
Plaintiff at one point said, you know, he wasn't bothered by those jokes.
so that's what the trial court said, but I think she misinterpreted the deposition testimony. My client was consistent that he was very bothered by these statements.
The response would be dumb American or something like that nature.
Well, there was, he did not say he would, my client did not testify he would say that. There is testimony from other witnesses that said my client would react that way. But if you look at the Penna case that the trial court relied on, the Penna did not say that that is a complete defense to a hostile work environment claim. It simply says that is relevant evidence a trier of fact can consider to determine if the harassment's unwelcome. But I think extrapolating that into saying, well, if the plaintiff at any time through his career made jokes back to the people who were harassing him, then as a matter of law, there's no hostile environment claim. I think that would be a broad misapplication of the Penna holding. And the trial court really relied on testimony from Denmark, who said that my client reported he wasn't bothered by the comments, but Denmark's testimony was not that simple. Denmark testified that my client said he was okay with some people saying it because he was friends with them, but other people, he was not okay with them saying it. And so, again, I don't think as a matter of law, you lose your right to a hostile environment claim because, you know, some people you're okay with saying it, but others you aren't. And again, that Denmark's testimony in itself contradicts my client's, which creates an issue of fact, which means it should have been submitted to the jury in this case. And as far as the notice issue, the court didn't even consider the constructive notice argument we made. And given that every witness that was working at the precinct said my client was frequently made fun of because of his accent, mocked because of his accent, supervisors joined in on it, supervisors witnessed it, you know, there's at least an issue of fact on constructive notice. As far as the retaliation claim, I think the trial court essentially said there couldn't be retaliation because my client didn't submit a complaint to the EEO office until after the investigation was launched. I think that, I think that's kind of putting the cart before the horse. The investigation itself isn't the adverse action that my client was complaining of. The adverse action was the discipline, the subsequent investigations for untruthful statements that other employees were not subjected to, and then the eventual termination. All of those things happened after my client complained about Hampton subjecting him to racial and sexual harassment. And we know that the investigators knew about my client's complaint because Denmark testified in this case that he told them that my client submitted a complaint to the EEO office. And so the court didn't really address the causation element. So I don't know if the court today wants me to talk about that.
You have 1 minute.
1 minute. Well, is there any questions for me?
Any questions? Anything else?
No, thank you, Judge.
Okay, thank you.
Thank you.
Appreciate your arguments. Well done. Case is submitted. We haven't reached the end of our 10 a.m. call, but it is, as I guess I didn't indicate, but it's nearly 11 a.m. So the court's going to take a brief recess and we'll be back in about 5 minutes or so. All rise. All right, thanks for your indulgence. That was more than 5 minutes, but we're back on the record. That brings us now to item 5, docket number 374887, RMH Solutions LLC versus Charter Township of Clinton.
Good morning, Your Honors.
Good morning. Could you lower that microphone, please? There we go.
No, I'm vertically challenged, so I'm quite used
That's
to
fine.
reducing
It's
that
been that way
microphone.
for more than just yourself.
Yeah. My name is Linda McRail and I represent the appellant and defendants in this matter, which is a conglomeration of various Clinton Township type details. I am the township attorney for the Charter Township of Clinton. I'm going to try and keep my presentation very brief here and rely on our briefs, which I think has really stated everything that you need to be able to make this decision, but there's just a couple salient points that I want to point out. Parties agreed through a stipulated order for what the court was to rule upon. And that was not drafted by one party or the other party. I think I took the initial stab on it. We had a 1-hour Zoom call. But regardless, we're all experienced attorneys. I've been practicing 30 years and I know opposing counsel's been practicing longer. So this was a joint stipulate order because what we realized is that the housing is currently classified as an I-1 condition 1 building, which means everyone who lives in floors 2, 3, and 4 have to be able to completely evacuate the building in the case of emergency without any assistance.
Zero assistance or limited assistance? I can't
Now,
remember.
I-1 condition 2 says you can completely evacuate with limited assistance.
assistance.
And opposing party said, well, you know what? I think we can qualify to become an
I1
I-1
condition two.
condition two.
Okay.
And then the issue that came up is, okay, well, what is limited assistance? What are we going to allow your residents to be able to need to evacuate the building? And we agreed that we needed the court to rule on that, with the possibility of appeal depending on.
Seems
how the
pretty
court
clear to
rules.
me, at least. I'm not speaking for anyone else up here, but this required a lot more than limited assistance to evacuate. I think it came down to floors 2 and 3 in the end.
Right. See, so floor 4 cannot be made into an
Right.
I-1 condition 2 because this is a wood frame structure of 4 stories.
Yeah.
So we're talking about floors 2 and 3.
And I think Appley
Yeah.
concedes
Y-
that
y-
floor
For
4
the
is
purposes we
out
did,
of the
yeah.
picture, yeah.
And first floor, don't even think about the first floor. That was a state regulated,
Right.
like memory care and higher care level. I understand that's been shut down now. But you're really, for your purposes, floors 2 and 3 are the ones that you're concerned about. And it does seem like it's a lot more than limited assistance. In fact, the lower court's ruling, when I read that order, I was like, great, we're gonna win. He's talking about, it's more than limited assistance if it has to be weight bearing activity. And I'm like, we got this, we got this. And then the very last paragraph, it says something like, for these reasons, we agree with the other guy. So,
Mhm.
it happens, but, you have to remember, condition 1, no assistance. Condition 2, limited assistance. If you get an I-2, which is building 2, 3s, and 4s don't qualify for an I-2 because of the wood framing, you can have any assistance. So we have to think about what makes limited assistance nugatory, right? I mean, we have to try and figure out a realm here where limited assistance means something. And we think that using the non-weight bearing, just guiding or directing someone physically or verbally, maybe even helping someone get their leg to the edge of a bed, maybe that would be limited assistance. But when you have to start lifting someone out of bed, putting them into a wheelchair,
Right.
wheeling it down the hall.
There seems to be a lot of evidence about that in the record. I think the problem here might be that I'm not sure that the trial judge ever made any actual findings
I agree
of
with you.
fact with respect to how many people required wheelchair transfers, how many people.
Well, I will say this.
So I
Yeah.
made that initial statement. I
Yes.
think there's adequate evidence to have made that conclusion. But I don't think the trial court did that here.
Well, I agree that the trial court did not make the best of records.
Mhm.
And in fact, that's why I filed a motion for reconsideration, was not thinking I was going to get some sort of relief, but to get the court to make that record that it was, supposed to make, because then we had the record to come to the Court of Appeals. But I will say this, in the stipulated order, we agreed for the court to rule on up to 75 people being bedridden. And there's been an argument that I made that up. I added in that order. I mean, nobody asked to set aside that order. We had 3 experienced attorneys, Jack Dolan, who's now retired, myself, been practicing 30 years, Mr. Hush was more than 30 years, less than Jack Dolan. So, and that 75 was actually requested by opposing counsel, because how do you set a number on, what percentage you're going to have be bedridden or not bedridden? In our fire drill that's mentioned in our brief, I think we identified 58 residents and about 60% were incapable of evacuating without any assistance. So,
This is a licensed facility, correct?
so what happened back in like 2019, give or take a year?
Counsel, I believe Judge Reardon had a
Yeah, I
question.
had a question.
Yeah, that's what I was answering,
answering
sorry.
the question.
Okay.
Yeah, sorry, I wasn't looking in the right direction,
No,
but
that's okay.
what happened in about
People
two-
blow off my questions all the time. You should see it at home.
I was just gonna say, you should see me at home.
In this
Um,
room back here.
Yeah. Yeah, you should see when your younger children is arguing War Powers Act with you and your attorney.
Okay.
I actually said, do you want me to call up David Viviano and we'll ask him? Anyway, I'm sorry.
2019.
It's a
was
licensed
licensed.
facility.
Oh,
Yeah.
so what happened is the state changed how they license these kind of senior living slash assisted living facilities.
The memory care facility as well?
The first floor is a memory care. It's no longer active.
Okay,
The second, third, and fourth floor, we have a combination of some people who can walk right down the stairs. Some people who are bedridden and can't get out of bed. Some people who use a walker but can manage the stairs with the walker. Some people who are wheelchair bound and would need someone to wheel them down there. But in 2019-ish, maybe a couple years before that, the state said, we're no longer going to regulate these type of businesses on floor 2 and 3. We're going to give them a home for the aged exemption. So long as the company that's providing the residence, the living space, and the company that's providing the care are separate entities.
so they're regulated differently from nursing care centers or your traditional nursing homes, those kind of
Yeah,
things.
they're given an exemption. I mean, unless somebody calls and says, hey, so-and-so beat somebody, there's nobody coming out and doing inspections or anything like that. They're
So
just
no
left on their own.
Lara unannounced state surveys or anything like that?
Nope.
So
Nope.
it's what we might refer to as assisted living as opposed to memory care. Is that?
Yeah,
fair?
and that's what I've been trying to clarify is
Okay.
memory care was on the first floor.
Right.
And then 2, 3, and 4 is anywhere from an independent senior living. It really depends on the people you're putting in the rooms.
Right.
We've been accused of trying to shut this place down. We're not. We're just asking them to put the people with the proper capabilities in the proper rooms
Right.
to be able to evacuate the whole building in
So
case
for a
of
layman, it's
emergency.
a step up from an apartment building.
What's that?
It's a step up from an apartment building.
Yeah, and my dad lived in one. I mean, there's different rules.
Yeah, they have different continuums of care, you know,
Yeah.
a lot of.
But the kicker, the way they're getting out of having to be licensed is because it's a different company and, any one of us can set up 2 companies, and have one actually own the property and one provide the services. They get an exemption from the state to be a home for the aged. So that's what's going on there. And quite frankly, partially what's causing this problem. So, but I think it makes it even more important to us as a township that we be enforcing our building and our fire codes to make sure that people can get out.
Safely evacuate.
This is our most vulnerable population, and they don't even know I'm here right now. They don't even know there's an issue. Their family members don't know an issue. This was originally discovered as a problem.
If anything ever happened, they know all about you.
Right. Oh,
Yeah.
I probably have endless depositions. There are many items, and I'm not going to go through a list because I think my reply brief addressed a lot of it. Items that are mentioned in the opposing party's brief that you can go 2, 3, 4 pages without a single citation. I just want to remind the court that this is just about that stipulated order, and if the judge did what the judge was supposed to do in accordance with that stipulated order, and the definition of limited assistance. Things are raised about certificate of occupancy, not relevant for your purposes. And I'll say not as heinous either. The original certificate of occupancy was printed out. It's a form, it's a PDF filler form. And so it cut off all of the codes when it printed off because it only printed what could fit in that tiny little box. Upon recognizing that that was the issue, they typed in the additional codes and printed it off. And quite frankly, it works to opposing parties benefit because previously the codes that were on there for occupancy code are A2, A3, and B. Well, A2 is a cafeteria, A3 is a common grounds, and B is businesses offices. So if we want to go back to that quote unquote original certificate of occupancy, then they can't have anyone live there. So I think that's another red herring. I'm not going to go through all of the items that.
I think we have a pretty good handle on things.
Okay.
So is there anything else you feel
let me take a
compelled
quick
to
look through
argue
here.
to us?
I think your questions went right along, so I'll just reserve whatever time. I
Okay.
have.
You'll have plenty of time for rebuttal if you feel
If
the need
needed,
for it.
hopefully not needed.
Right.
Morning, Your Honors.
Morning.
I think Ms. Correll is correct. I do have, I'm starting to hit close to that 40,
Uh-oh.
40 or 39. But I will say this.
Please give us your appearance.
Brian Hurst was swearing on behalf of RMH this morning. Interestingly enough, and I do want to start back at the beginning because I do think that it's important. The case kind of took on a little bit of a life of its own as it was being litigated, and in some respects, probably not really litigated because, and to the judges.
It appeared to me he was trying to settle the case and going to great lengths to try to do that. And maybe that kind of explains where things might have gone a little bit haywire. I don't know.
He's a unique judge. And I say
Yes.
that as a compliment, by the way.
I know him
It might
well.
be recorded. No, I'm just kidding. No, he
We
really.
practiced at the same law firm when I was a brand new lawyer.
Oh, okay. He really is, by the way. And so what he did was, you know, when you look at page 1, before my client put one dime into this property, which ultimately is over $32 million, before they put one dime in there, they go to the township, they get all of their approvals, they make a brand new city or township ordinance on our behalf. And what they get is not only do we have are we now rezoned for it says to the Concord Inn property and building for use as an assisted living memory care facility. And then they say the new ordinance that they're creating. So it was literally created for us. We get all the approvals, we're ready to go. Now we start rehabbing the building. By the way, one of the things that I will talk about the C of O in a moment, we're also licensed with a liquor license. Okay, we have a gym and we have a catering facility. It was a hotel.
Right.
We retained all of those, all the permits, all the permissions. Therefore, when that C of O gave us certain business operations, the rights to have liquor and what have you, we're not using that at the assisted care facility, although I think that's a big push right now that they are doing that in some of the facilities. Uniquely, and I'll jump ahead just for a moment, what this judge tried to do, he had phone pretrials, he had some in chambers pretrials, and what his concept was, first of all, he gave us a status quo order. He said after 4 years of the township allowing them to run and operate their business, and you've had no issue with them. Now all of a sudden there's some pushback because there's some political issues that are going on. My clients were now, as the aged population starts filling up the facility, 911 gets called more often. And the fire marshal is the one that really starts it. And he says, it's going to cost you $800 every time we have to come down to your facility. And it's like, you can't do that. So they started pushing back. That then falls by the wayside. And then all of a sudden the building official starts coming down on us. We satisfy him, we got the fire marshal. Satisfy the fire marshal, we've got the building official. And one of the things, and it's quintessential, I think, in this case, is the judge asked, what about their building doesn't qualify as a category 2? And the answer is nothing. We qualify.
Not the building, it's the people living in the building. That's the problem.
Actually, with all due respect, it's in reverse. First, you have to have the facility, and the facility has to meet certain requirements and fire rating.
And they gave all those approvals before anyone lived there. Now you got your certificate of occupancy. They changed the law in order to allow you to use this facility as you have been. So I think you might say they kind of bent over backwards to help your client initially, but all that happens before a single soul is moved into the building. Now you have people there.
Nothing's changed though. And let me give the court an example. One of the things that happens is that they have the big grand opening, and the first people that populate our building, the township is out there with us during the celebration, and guess how they get there? In their wheelchairs.
They probably shouldn't have gone in there then, should they?
I don't know, but if the township certainly didn't find, by the way, there is not an issue with that, but the township certainly didn't have an issue with that either. The problem that they ran into was 4 years later. Now there's an issue between RMH, the folks that are administratively running the facility, not necessarily the hands-on people running it, and the township officials. Now, all of a sudden, 4 years later, now we've got issues. The only thing, their engineers met with our engineers, and they said, what is it about the facility? Because that's one of the things that the court relied very heavily on in the lower court. And it said, this is nothing more than a designation. If they meet the requirements, for an example, you've got the stairwells. The idea is not to get the residents, and there, by the way, there's no medical care. I see that's been argued. There's no medical care that is rendered. This is not one of those facilities. If somebody needs help getting out of bed and getting into their wheelchair, if they are that sickly, they're out. We just don't have that. They have to, and again, this wasn't done just the attorneys coming in and sweet talking a judge. The judge required the parties there, my people, their people. And one of the things the judge did was ask questions. And one of the things that they asked was, and what do you do? And so this was the fire marshal giving the court and conceding with the engineer. One of the things they do when you look at the stairwell is a certain size. And what they do is when there is a fire, and there are several wings of the building. So if there are 3 areas of let's say on the second floor, if you have 3 different areas, these residents would go to this stairwell and these would go to their stairwell. And one of the things is that the judge asked is, how do you determine who's there? Who's there to tell them you go to stairwell 1, you go to stairwell 2? Well, it's the amount of employees that they have there that are able to give the direction. And one of the things that was important is that most of the time, the way these operate, God forbid there should be a fire in any of these facilities, no matter whether a category 1 or a category 2, because these are elderly people. And in the best of circumstances, it would be a horrible situation. This one here, one of the things, and the fire marshal conceded to it, is that what they do is they get them into a stairwell. Now you wait. You don't make the decision on getting those residents out. You wait to be instructed from the fire department what to do next. And they said, we have to have certain windows, for an example. And those allow the bucket to come up and it allows to take people out. So the windows are changed. The doors are changed. Everything that rates as a category 2, we are. The only tweaking that they required of us, which we installed because and that was one of the things we agreed to in the order, is that when you have a large floor, we agreed to split the floor up with doors. They're actually automatic doors so that you can split the floor in 2. And that way, if God forbid you have a fire on, let's say, the right side, it will not, it's rated for fire 1.5 to 2 hours, will not get to the other side. That was the only thing different that we didn't have in place. We did, and the agreement was by stipulation that we would do it by June of 25, and everything is done already. That was the only thing. Everything about our facility is a category 2. That's number 1. That's point A. As it relates to the issue as getting the people out, they had not only the plan, we went overboard. What more do you want from us? We're not required under even a category 2.
Yes or no. I mean, that's all dependent upon, you can put whatever label you want to on the building. Whether you're compliant depends on who is living on floors 2 and 3 and what their capabilities are, which is a fact question that your opposing counsel said the judge never resolved, and I don't think the judge resolved it.
So I think the judge did. One of the things the judge did was the judge ordered both parties to go in there and determine 2 things: the amount of residents, the amount of square footage where they can shelter in place at any given time in each and every one of the stairwells. There are 3 on each floor, and they're broken up by the amount of residents. And that's one of the things. So we went back to the court. We had the list. We know if those people can't get downstairs on their own to the dining room to eat, they don't come in the building. And they're residents. One of your honors made the comment, is more like a glorified apartment building, where it's the next level up from being an apartment building. And I think that's true. That's exactly, you have the elderly that are living here, but it's more of an apartment building. Floors 2, 3, and 4, those floors have lease agreements. That's exactly what they are. So those residents have rights also. If they can't get downstairs to eat, they're not allowed. So this concept of you got to get them out of bed, you got to get them into a wheelchair, it's absolutely untrue. And that's one of the things that happened with the judge.
That would have been a great argument, which I'm sure you did make to the trial judge. But again, I don't know that he ever resolved that factual dispute.
I think the part of the problem, and I said he's unique.
Mhm.
And one of the reasons he is unique is because taking all the facts, taking whatever the concerns were on both sides, he then resolved the issues. And then,
He made a conclusion.
well, he
And-
didn't just make a conclusion,
Yeah, I
and
don't
certainly
think
not
you can,
blindly.
assume from that, well, because he reached this conclusion, that means he must have made the following findings of fact when he didn't say that
Well,
he had.
Well, I think here's the difference. Again, unique in that how he was able to get an ultimate resolution out of the parties. We're not required by law to do certain things that we agreed to. For an example, the evacuation chairs, we're not required to do that. We did it. How many people we were going to have on each floor, we agreed to do it. So every time there was a concern that was raised by the township globally, those concerns were then memorialized by the court saying, all right, what are you going to do about it? How are you going to resolve that? So it was not an issue of the building meeting category 2. And by the way, the township is not going to deny that if our building was a category 2, each and every one of those residents in that building are fine. It's not an issue of the residents. It's an issue of the category. For category 1, they're arguing we can't have certain people that need assistance. Under category 2, we can.
Limited assistance.
Yeah, by the way, limited assistance. And one of the things that we said is that every one of those people, every one of them has the ability to, they can get up and downstairs on their own to get, because if they can't get to the meals in the dining room, they're not allowed into the building. That we don't take them. We don't accept them. But I will say this, part of the assistance, and this is one of the discussions that we had with the judge. If you have a residents that are in a room and you say to them, go to the stairwell and stay there until, is that assistance? It's a directive? I don't know. I don't think it's assistance. I think it's a directive. Go over there. You don't take elevators. Or that would be the first thing you would tell
We'd
them.
be here if that's all that was required, but I think there's a lot of evidence in the record that much more assistance than what you just described. is
There's
required.
evidence in the record because you're being told by the township
Right.
that this was an issue.
That's how litigation works, right?
Well,
They
not
put in
one-
their evidence, you put in
So
your evidence, and
so
then
here-
the judge, in this case, is to make a ruling based on disputed facts.
So he did make a ruling, number one. And number two, here's what I would say. That part of my issue on appeal is the township goes out there, they make a resolution. They agree on it. They tell us, go spend thousands of dollars and upgrade the building with these doors that split up the building. Go get the evacuation chairs, do whatever it is they tell us to do, a deal brokered by the judge or otherwise, and we do it. And then they say, oh, good. And now we're going to go to the Court of Appeals because we don't agree that you should have that designation. And I think that's what a lot of this hinged on. This 75 people, by the way, that they tout throughout their brief, they have no proof of that. It's absolutely untrue. It was untrue when they said it to the judge, and it's untrue as they sit here today. And I will tell this court that that C of O issue, okay, throughout the course of this litigation, they have lied to the court and they got caught. And that C of O, with all due respect to counsel, and I have a good relationship with her, so I'm not attacking her, but that issue with the C of O, they finally acknowledged and they admitted, they backdated it by 4 years. This didn't come out of a computer and there was an issue. I gave this court 3 pieces of litigation against my client where there was a lien that was filed against the property.
I'm not even sure that we're concerned with certificate of occupancy in this case, to be honest. A lot's being made of it, but I'm not sure. Mr. Hirschfuse, I feel like we're beating a dead horse to an extent here at this point. Is there anything else you feel compelled to argue?
I've got a lot more to say. I'm kidding with you.
Can I ask you a question?
Sure.
Okay. Is limited assistance defined anywhere under either the codes? If we're looking at the building code, the fire code, anywhere?
So it's not, and I think what the court did was the court extrapolates and the court gives its definition in the order, the court identifies in the opinion in order how it arrives at its definition. So to answer head on, no, it's not. And while both counsels, the way of litigation, argue what limited assistance may be, at the end of the day, none of that was, I don't think anybody had, we both had different codes that we were relying on, and the court extrapolated and gave, for example, on page 4 of its opinion, it went and it talked about the definitions of custodial care, and then the court went to the next step, incapable of self-preservation. And then it went into its arguments about institutional groups for I1 and then I2. Those are the categories, category 1 and category 2. So the court actually identified how it got there. And I will tell the court, I made a very generous argument to the lower court. And he didn't buy some of it. I'll tell you straight out. I mean, he was not critical of me, but he was critical of how my clients got there. But I think one of the things that there's no question that after 4 years, one of the things that he wanted to do was not only keep a status quo, but now run these people down to the bankruptcy court, because that's exactly what would have happened. Nothing at all had changed, not the population, not the type of population we were servicing in 2021 when we opened the doors. Nothing changed. The only thing that changed, thank God, is that they got more residents into there. They had to work it. They were a brand new facility, so they had to get more people in there. That's
You confirm that floor 1 is no longer operating as a
no,
nursing home or
as a member
Memory
care.
care.
memory care.
I can't, and I'll tell the court what happened.
That's all I needed to hear.
Yeah, by the way, I think
That's
it
all
is.
I needed to
Yeah, I
hear.
think it's still in operation.
That's all I needed to hear.
Well, it's in my brief. I mean, I think that is an issue.
Anything else for us?
Yes. As it relates to you don't want to hear about the memory care facility, that issue.
No,
and
because
that-
it's not an issue. I had one question. I just needed a one-word answer.
Who reported us? As it relates to the 4th floor, I don't want that to be a foregone conclusion that we conceded that the 4th floor was different than floors 2 and 3. Certainly floor 1, but then 2 and 3, what we did was, for purposes of resolution, we didn't fight it, because that was something that they were bent on. We're not giving up on the issue of the 4th floor, and the judge's position was resolve it for floors 2 and 3, and then you've got 4th floor, which are you can't put anybody there that needs any level of assistance. And that's exactly what happened. So I know Your Honor made the comment before, and certainly that was not intended by saying, oh yeah, we don't qualify. I think we argued that we were qualified for it, but that was strong enough of an issue that we let it pass, and we agreed not to use the
So
4th.
why are we talking about it?
Because there was made, and I think it was by Your Honor, that we agreed that the 4th floor didn't meet the requirements.
No. Okay, go ahead.
Okay, that's it. I'll rely on my brief for the rest, but I would say to the court, I think that the lower court did make, and again, maybe unique or otherwise, I think one of the reasons that he met with counsel is he got them to the point where they could reach a resolution. He reached a resolution on the issue of the law, but from an issue of the residents and who was being serviced in that building or who was taking residency in that building, there was nothing new and nothing changed from what had been allowed for the earlier 4 years and now 7 years later, by the township.
No
Anybody?
rebuttal?
I'm just going to go through a list. Opposing counsel stated that they go to the city and get all of their appropriate approvals. I want to clarify that what they received was their rezoning approval and their variance to go from 3 floors to 4 floors. They did not receive any special dispensation with regard to the building code or the fire code, which is still present. I also want to clarify in their briefing, they attached site plans saying, see, it doesn't say anything in here about it being I1, condition 1 or condition 2. They attached their site plans, which has where you're supposed to put your shrubs and where your buildings are going to be located, but not how it's actually built. All rezonings, really anywhere it should be, but especially in the Charter Township of Clinton, are done by an ordinance because we have our plan that everything is zoned in our ordinance, so we need an ordinance, so there's nothing special about that. I want to clarify that, you know, they didn't really get up and running until early 2023, by the time they built and they advertised and they got people in there. And it was in November of 23 that we got a call that our fire marshal responded on for a 500-pound man that had unfortunately soiled himself and they couldn't get him out of his chair. So if they are telling you that everyone can get down to the cafeteria, well, one, the elevators are running then. They're not running if there's a fire. I call Balderdash on that because we had the very first person calling that was so heavy. It took multiple people and the fire department to move them. We ran a fire drill. It's in my packet, where we were told by staff as we're knocking on doors, you don't need to bother them. They're bedridden. I have never said that there's 75 bedridden people there. There's some population of bedridden people there. The 75 was proposed by opposing counsel because he wanted to be able to have, there were 75 rooms, up to 75 people that could be bedridden so that he can put whoever he wants to within these rooms. So, and he agreed in the stipulation that it would be up to, that's a stipulation, an agreement. Not only did he ask me to put it in there, but he signed off on it being in there. The recertificated, they keep saying that they're all compliant with this I-1 condition 2. They have taken, there's certain steps they need to become a condition 2. They have to file some forms, they have to get some permits, they have to get their inspections. Some of that work has been done to date. It was supposed to be done a year ago. It's still not done. They still haven't asked to be recertified as a I-1 condition 2. And they didn't ask for a stay of the orders either. I mean, there was an order saying it was supposed to be done. I think it was June of 25, and no stay was requested. We've been pending in this Court of Appeals, and as far as I'm concerned, they missed their window on that. The fire marshal 100%, if he listens to this video, I need to make it clear, never said that these people just have to get to the stairwell and then we'll worry about evacuating them. What he has said is that people are supposed to evacuate the building when the fire department gets there. Their job is to put the fire out. I mean, obviously when there's people in there that haven't evacuated and they need help, they're going to do it. But the way the system is supposed to work is people get themselves out. By the time the fire department gets there, they go in, they put the wet stuff on the hot stuff, they put it out. Everyone's safe, everyone lives, no damages. And I think that's all I wanted to address. Oh, the lift assistance. It's a very common ordinance. Many cities are doing it right now. It's called a lift assistance ordinance. And what it says is that in these facilities that are charging thousands of dollars to be assisting with the care in a 1-bedroom, no kitchen apartment, that when they call our department to pick someone off the floor, when they're telling family members that they can take care of this, and somebody's sitting on the floor and they're making us come in, we do have the ability to charge the facility, not the resident. Our cost, I think it's about $800 in lifting them. And, you know, we're in a situation where we only have so many resources. We're at an all-time low of firefighters, paramedics, EMTs. And if we're spending all of our time going to senior citizens just to pick someone off the floor, I mean, I feel for the person on the floor, but they're paying thousands of dollars for a facility that is refusing to pick them up off the floor. And we will send them, it's not a fine, it's a bill for our time.
I think we understand. Do you have anything else for us?
Nothing, I do not, thank you.
Okay, thank you. Case is submitted. Item 6, docket number 373223, In re Chance.
May it please the court. I'm Celeste Dunn and I am Celeste Dunn. I am here on behalf of the appellant, who is the respondent, Ms. Pamela Wickings, in this matter. I'd like to give the court just a brief overview of the dangerous animal statute. I don't think you even need to do that. We've read it. We know what this case is about. You could just
Okay.
get on with the argument. I understand it's a provocation issue and she was down on the floor with her face in the dog's face, potentially with the shoe in her hand, and with a raised voice.
That's exactly right, Your Honor. The court understands it. And obviously, the legislature does not feel that a dog bite is warranting a euthanasia or a confinement if it doesn't meet the statutory factors. Or the legislature has clearly enunciated exceptions that make animals not dangerous. In this case, falls squarely within that exception.
And
Thank you
she
very
admitted
much.
that she provoked the dog.
She admitted she provoked the dog. Thank you very much.
Thank you. Counsel?
May it please the court, Alan Francis for the appellee city of Port Huron. And I very much appreciate that the court's clearly read the record. This issue was tried. We had a judge who heard the evidence, who heard the testimony from the victim. The statement about provocation was made within days after having her nose repaired with cartilage from her ear. The victim testified in front of Judge Monahan that when she said that she was provoked, she didn't mean provoked. She didn't even know what provoked meant with under the legal standard. And it's different here. A legal standard is what a reasonable person would expect a reasonable dog, whether you'd expect a dog to act like that.
It's an objective test, right?
Correct, but it's also, and they admit in their brief, it's the totality of the circumstances. So it's not what I would expect your honor's dog to do. In this situation, it's what I would expect a dog that I've known for 2 or 3 years to do. It's what I would expect, for example, my sister's dog to do, who's taken my shoe and I've said, can't have my shoe. So
Did you get your
like
face
this?
right up to the dog and speak in a
I
loud
have.
voice?
Yeah, because the dog has never displayed any sort of issue with respect to any sort of temperament.
Your
to me at
client's
all.
animal control officer advises against that.
No, and I appreciate that was the
No?
question. Well, he said in first, and I'll read the testimony. At first, he refused. He said, I can't answer that question. It was on cross. Then the follow-up was, you're telling me if someone came up to you on a street and asked you, and he would say, I would say no. But that is not, first of all, he's an animal control officer.
Follow-up question to that would have been, why would you so advise someone?
Would have been, but wasn't asked.
Right, I get that,
yeah.
but we know the answer.
I don't think we do. And why I suggest that is there are a lot of facts missing from that hypothetical. First of all, it's a stranger coming up into him, asking him on the street. He doesn't know whether you know the dog. He didn't say why he wouldn't. And more importantly, he's an animal control officer. He has a different level of understanding of dogs than a reasonable and ordinary person does. So is it maybe a best practice in dogs you don't know? Absolutely. But this was not a dog she didn't know.
Wasn't her dog.
Correct.
It was a friend's dog.
Correct. That bit her nose off
Mm-hmm.
because
Yeah.
she talked sternly to it.
Mm.
Yeah,
Mm.
yeah. The court's aware of the the facts.
She got in its face and potentially also had the shoe in her hand. And was-
Potentially.
And was speaking loudly to the dog. I don't
And-
think there's a dispute about that.
Correct. She was speaking sternly to the dog, I think was the testimony. And we have a judge who heard that from the parties and said, this is not a close call.
I don't think it is either.
Fair enough, Your Honor.
Okay. Anything
you.
else?
No, thank
All
you.
right. Any rebuttal, counsel? Okay. Thanks very much. Appreciate your arguments and your appearance here today. The case is submitted. That brings us to the 11 a.m. call. And so I'll just briefly say again to the attorneys and parties who may be arguing, we've read your briefs and we've had reports on the cases. You don't need to belabor the facts. Just cut right to the most salient legal issues and let us know succinctly why you think you should prevail. No proper names in cases involving children or protected persons, initials only. With that, I will call item 7, docket number 372622. Dana Levette Glenn versus Bradby Townhomes Condominium Association. And plaintiff appellant is endorsed to argue via Zoom. Pro per. Okay.
Hello.
Good morning by 2 minutes. Are you
I'm the plaintiff, Dana Glenn, or the appellant, Dana Glenn.
Glenn, I'm sorry.
Yes.
We have the names flip-flopped on the call sheet here. So, Ms. Glenn, you can give us your appearance and proceed to make your argument.
Yes, well, may it please the court, my name is Dana Glenn. I am the appellant in this matter. My first argument, I'm going to go with my fourth argument in my brief, because it's the primary reason I sought to appeal the case, or rather the decision in the lower court, is that I'm requesting a remand of the case with instructions to allow me to amend the complaint. Okay. I acknowledge up front that the request to remand for leave to amend the complaint might not be considered properly preserved by this court. However, I did state the intention to amend the complaint or file a request to amend the complaint at the end of our motion for summary disposition hearing. However, it appears as though the recording had stopped and I wasn't aware of that. When I made that request to the judge did acknowledge it and stated that I could do that if I chose to do so. So under Michigan's raise and waive rule in the civil cases, this court, of course, is not obligated to consider it. However, the issue is purely legal. It involves an application of MCR 2.116 and MCR 2.118, which strongly favors allowing amendments unless they're futile, unduly delayed, or prejudicial. And I don't think either one of those applies, as I argued in my brief. The facts needed to decide this are already in the record, including my proposed amended complaint, where more specifically I kind of outline the actual breaches or instances of breach. And addressing it now is necessary for proper determination of the case and to avoid a manifest injustice, as denying a potential meritorious claim on a technicality would undermine the liberal amendment policy the Michigan courts follow. So therefore, I respectfully ask the court to exercise its discretion, consider this issue, reverse the trial court's implicit or explicit denial of the amendment opportunity, and remand with instructions to allow me, the appellant, to file an amended complaint. All right, so my next argument is the breach of contract claim and the statute of limitations. I'm asking the court to reverse the lower court's decision because the appellee, Bradby Townhomes Condominium Association, actively breached a legally binding mutual release agreement by collecting and attempting to collect fees dating back to October 14th and earlier. And October 14th is the date of the mutual release. The central point of this argument is that the mutual release was freely signed and executed by both parties. The contract specifically released and barred any claims, dues, or assessments dating from October 2014 and earlier. So despite agreeing to the release, the HOA collected and or retained those exact barred fees. And under Michigan civil breach of contract law, a signed mutual lease is a fully integrated and enforceable contract. And by collecting the pre-October 2014 funds, the HOA clearly violated the terms of that release. So with respect to that, I'm asking the court to allow, rather for the court to acknowledge the lower court erred by allowing the HOA to collect on a debt that was already extinguished by the mutual release. The other kind of sub-argument that defendant raised was the statute of limitations. So I'm asking the court to reverse the lower court's decision that my breach of contract claim was barred by the statute of limitations. They're claiming that the alleged contract claim or breach of contract claim accrued in 2015. I'm personally a little unclear about that claim because they just stated it without explaining why that was the date that they are arguing that the breach occurred. I obviously don't agree with that. I will continue by saying that the 2015 payments were made because I was legally obligated to pay assessments due from November 2014 forward. And that was the intent when I made those payments in 2015. Defendant also agreed that I was required to pay assessments past the date of the release, which is what those payments reflected. More specifically, because the cause of action accrues on the date that the breach occurs, the breach and the multiple breaches did not occur until the appellee took legal action to recover past due fees from 2015, 17, and more specifically in 2018. And what I mean by that is I paid fees in 2015, but I stopped in 2015. So it wasn't until about January 2018 that they attempted to collect fees or dues that were due from 2015 until or up to January of 2018. But they also attempted to collect the pre-October 2014 payments with that January 2018 lien. That's the first accrued breach by the HOA. The second would be a subsequent lien and collection of fees. That lien was filed in, I believe, June of 2021. So because my claim for breach of contract was within the 6-year statute of limitations, which would put me for January 2018, would put me sometime in January 2024, I was well within the time period to file my cause of action for breach of contract. The other two, the second argument was that the lower court erred by granting defendant's motion for summary disposition by holding that I could not sustain a claim of tortious interference. I'll be brief with this one because the lower court found that the plaintiff appellant entered into an ESCO agreement with First Premier Title Agency sometime in January 2021. But I failed to ask the defendant or the appellees to release the lien prior to entering into the ESCO agreement. And again, this is what the judge held. However, the lower court ignored my evidence that showed an email clearly stating and requesting a release of the lien by my HOA association. So unfortunately, I ended up having to pay and had a lot of money held in escrow for several years post the sale of my unit because of this. So I'm asking the court, of course, to remand that particular issue. And my last issue is that whether the trial court erred by granting defendant's motion for summary disposition by holding that I could not, as the plaintiff, could not sustain my claim of a violation of the Condominium Act. So the trial court found that the bylaws stated that I was required to pay any past due assessments at the time of closing when I sold my property. I sold my property in July 2021. So at that time, that's when I discovered that they had added additional fees at the time of closing. So what they did is they added fees specifically for December 2020, which the record clearly showed were paid with the payment of my the prior lien, which of course I had to pay before I closed. So those were paid, and they added additional fees for 2022 and 2023 that were not assessed. And again, I sold the property in 2021, so they would not have been due, or they would have been due to the subsequent owner. And that's the end of my arguments, Your Honors.
Any questions for Ms. Glenn? No. Okay, we see none, so we'll hear from your opposing counsel.
Okay.
Good afternoon, Your Honors. Nancy Dembinski on behalf of the defendant appellee in this matter. Having been here earlier and heard the not warning but recommendation twice to keep it brief, and
You could
you've
call it
all
a
read
warning.
everything.
You could call it a warning.
I am definitely. And
You see what happens when someone violates the admonition.
I did
Yeah.
take that to heart.
Mhm.
So I don't have anything that doesn't, I guess that isn't argued in the briefing. I think both sides of this case have tried to make their positions known in our writings. And appellant was very succinct in her argument, so I will say the same. We're asking the court to affirm the trial court. The trial court outlined its reasons, citations to the record, and legal conclusions in its opinion in order, granting summary disposition in August of 2024. The court found that the breach of contract accrued in 2025 when additional payments started to be made that defendant accepted, after the 2024 release. We've also argued that the 2024 release doesn't prohibit the town, or the township, I almost said, having listened to that case,
Yeah,
the
right.
townhomes from collecting into the future. And again, that's all spelled out in the brief, so I won't reiterate that. We've again asked for affirmance on the tortious interference claim. The defendant did not interfere with the escrow. The lien was in existence. We didn't know about the escrow. We didn't interfere with that. As far as the Condo Act argument, the bylaws do allow for assessments for those common areas, and in this case included the roof. And the bylaws say unpaid assessments must be paid at the sale of the unit. And at that time, that was asserted to be whatever it was that was articulated. We don't believe we violated the Condo Act bylaws by asserting what is plainly and unambiguously allowed therein. With respect to the amendment of the complaint, I think I did include that in our brief. That was made after summary disposition. And if something was said that wasn't on the record, I was not at the court that day, so I didn't have that information. But it was made in a post-summary disposition filing, which the court has in its record. We've cited to an unpublished case, which we've argued supports our position there, that the request comes after summary disposition granted, discovery's over, and it's about a year and a half after the case was filed. And for those reasons, the court did not abuse its discretion in its. Unless the court has any questions, I'd respectfully request that you affirm.
Any questions for council?
I like
Okay.
I'm talking very fast. Thank you
Thank
very
you,
much.
Ms.
Your Honors.
Kaminsky. We appreciate it.
We've recorded it all.
Right.
Thank you.
Ms. Glenn, do you have any rebuttal?
The only rebuttal I have is with respect to the violation of the bylaws. Because again, I just want to reiterate that the assessments that they're allowed to collect are assessments that were due, not assessments that were previously paid or assessments that were not yet due and were liable to the subsequent owner. That's all.
Okay. Ms. Glenn, I have one question for you. Are you an attorney?
I'm not a Michigan attorney.
I see. Okay.
You're not a Michigan
There we
attorney.
go.
I-
I had this-
That's the issue for me.
You an
If
attorney?
the answer had been no, I was going, well, I'll commend you on your argument either way. It was well done. So, yes.
Thank you.
Very well.
Did you go to law school?
Yes, I'm an out-of-state attorney.
Okay, what state?
California and DC. I live in the DC area now,
Oh, okay.
Okay.
but I'm from Michigan, of course.
Those aren't easy places to get licensed. So, all right. Thank you very much.
All right, thank you.
Very much for your arguments. We
Yes,
appreciate
excellent,
it.
excellent argument.
And the
Thank you.
case is submitted. Thank you. That brings us to item 8, docket number 375082, CMT versus TOF. Is Attorney Siegel? Yes, you're back.
Your Honor,
Good afternoon.
the court, Ashley Siegel for respondent appellant. Your Honors, I'm asking this court to review the trial court's deprivation of my client's due process rights de novo and vacate the order of protection. The trial court had 4 opportunities to make a record that could be reviewable and that would comply with my client's due process rights and comply with the court rule and the statute, requiring that the reason for issuing the PPO be in writing and on the record. It was neither. When my client came to me originally with the order, typically I tell him, trial court gets reviewed for abuse of discretion. He's found these facts. Thanks for coming in. But we didn't have that here. So then we request the transcripts. Again, don't find anything in the record that really states why this protection order was issued. So then I file my appeal in the Court of Appeals and I ask a motion to remand. In the motion to remand, I said so that we could have the motion for reconsideration held in the trial court. And also maybe this court could ask the trial court judge to expand the record if it's so found. Well, the order on remand was limited to the reasons brought up in appellant's motion for remand. So at the hearing for reconsideration, I pointed out to the court, an issue we're having is that it's hard to review this record, and we don't really know why this was issued. So,
What's the mystery?
Well,
It
I
doesn't
mean-
seem that mysterious to me as to why it was issued.
okay, maybe your guys' opinion will clear it up for me.
Okay. I don't
Oh,
think
because I'm sorry, Your Honor.
Thank
Oh
you.
my gosh, I never
Oh.
thought I would do that.
I was
I
thinking
never-
still about my
I'm
question.
so sorry, Your
No,
Honors.
it-
I never thought that would happen to me.
It- it
why
That's
happens-
a
did-
pet
it-
peeve of both of ours,
it
actually, and I
happens
missed it.
every month, every single month.
You're
I-
not
So,
alone. but
Yes,
Just
so,
bear it in mind.
okay, right, so we'll just, we'll move.
Your Honors, I will tie a string around my
Okay.
finger next time because I heard the admonition twice today and every time I'm here, and I can't believe I fell prey to it.
That's
Well,
So sorry.
It's the way people speak these days,
Right.
right? So,
So I was unable to advise my client about why this PPO
Well,
was
your
issued.
client was in the courtroom when the tape was played, right?
Right, so if we're gonna move to, I kind of look at this case in two parts. One is the deprivation, the inability for a higher court to review it because there's not a finding of fact on the record or on the order. And
That
then,
was an earlier case.
and
Yeah.
then an abuse of discretion because the facts don't rise to the level of harassment.
Okay,
Oh.
let's talk about that. Go
Okay.
ahead and tell me why. And I understand there were a couple of the, right, the petition is filed and the petition includes not only the allegations, but also I think it's 6 police reports. So to the extent that the petition is inconsistent with what the police report reflects for, let me see, I think it was one of these dates, there was an ordinance violation that was reported and there was a car on the respondent's property and the police responded to that. That I understand is legitimate conduct. That cannot qualify as harassment under the statute. And there was, also the incident where respondent claimed that petitioner claimed that the respondent was trespassing on the property by marking the trees and walking the dog. And there was a video where they said, look, here he is, he's trespassing. But when the police looked at the maps and looked at the global, yes, they discovered, no, okay, so I get that. Those two are legitimate activity, but go ahead and tell me why the rest of this does not qualify as harassment.
A few of the things, one of the issues that the trial court did bring up in the motion for reconsideration is, didn't you say something about his brother and it being Suicide Awareness Month?
Right.
And also the trial court, of course, took exception with the use of a racial slur. We do have slurs.
Use it
Plural.
multiple times. yeah.
Multiple, repeatedly, constantly, according to, and these people were both placed under oath, right, at the time of the hearing? And the petitioner is saying, this is constant. He's referring to me. And I know none of us is going to repeat that word on this record, because it's horrendous.
So and I'm not disputing that one bit, but we do have case law out of this case, out of this court, and not to mention the statute itself specifically says that constitutionally protected speech.
The political case, I think I was on that one that dealt with a supervisor that a neighbor didn't like. I think a supervisory board member or something like
I
that.
think this one I think dealt with, not with the use of this particular word.
It didn't. It dealt with political speech.
Well, in the case that you cited, and the court distinguished it based on the language that was used. Right?
So first of all, MCL the statute
No,
says
I get
okay. And then
Yes.
also there's the case, the PPO case that I cited in my brief. And that had to do with someone saying, here comes your massa, which is
Right.
also racially charged. And it was also.
It is not this word.
Right.
And I agree with, I can't say that I disagree with the judges saying that is distinguishable from this. And repeatedly, not just the one time, as that case was, and in fact, that the court based its ruling solely on that statement in the case that you're citing. And here, the court had the benefit of hearing the recording and had his statements under oath that this was a constant. And counsel, I don't know what to say about the argument being made that they were playing a game with each other. It's not. It's a offensive term that he repeatedly used, that he lied about initially before he said, well, let's just say for argument's sake, I did say that. He did say it. It was on video.
So we can also break this issue. We can kind of move past like what exactly was said, because harassment, as your honors know, is it's very specific, explicitly stated in the statute, unconsented. And that's where I said that this was a game that they were playing back and forth, because it was. And then specifically in that incident, when he used this horrible word that shall not be uttered, the petitioner had just called him a really bad word that is, I don't want to talk about it.
No, I know.
Not necessary.
So it was, what my point is unconsented. Harassment has to be unconsented to. And I think the going back and forth shows that it was consented to, that this was a going back and forth. And also, there was never any time where the petitioner asked for this to stop. Actually didn't even ask for it to stop in the courtroom. He didn't ask the police, hey, tell him to quit talking to me. Don't come to my property. If you want to communicate,
Well, the
do it
court
by
did
letter.
that in its order.
He went to court, is what he did.
Right, but he had never asked for this to stop. He had never said, don't talk to me, don't come onto my property, don't, it was a back and forth. It was a trading of barbs, a trading of moving bricks back and forth on the property lines,
I guess just because it goes back and forth doesn't take it out of the realm of harassment. I don't see why that would make a difference. I mean, I understand it adds some context, but I don't think it transforms the respondent's behavior into something other than harassment just because the other guy is doing it too.
And if this court isn't moved by the unconsented or the or the other issue that I just brought up, I would lastly add that there's no evidence of emotional distress. The petitioner didn't testify that, this is making me lose sleep at night. I'm stressed out about this. I can't, it's making me feel afraid in my own home, anything like that. He didn't allege it in the petition.
Other than saying it was constantly being said to him.
But he didn't say that, that he felt terrorized, threatened, because the court needs to make two findings that this actual petitioner felt harassed, terrorized, and threatened, which would be very fact specific to the person.
Well, there were repeated calls to the police.
And that a reasonable person would feel harassed, threatened. This was a trade, and I know the word he used is not, and which is why I cite that case, because, and I cite that constitutionally protected speech.
You're not really arguing that the use of that word is constitutionally protected, are you?
Can it be a fighting word?
I don't think there's any court in the country that would, at least in this context, that would conclude that the use of that word is
right. It would be a
protected.
fact.
Maybe in an educational setting,
fact specific
might be,
inquiry,
but not in a neighbor to neighbor dispute such as we have here.
I'm not aware of a First Amendment carve out for specific words.
In my third year of law school, I learned it at Wayne State up the road here. That word in particular was the exemplar when Joe Grano asked us, are there any words that are off limits? And guess who raised his hand and gave this as the answer? In part, as Judge Letica suggested, because it
The
is
history,
regarded as a fighting word.
right, the history of what that word means.
And the word that the neighbor used to him was also a horrible derogatory
But he's
word.
not the respondent here.
But that goes to the unconsented.
I understand your argument.
Yeah.
I understand.
He
your
was not the petitioner.
When the other person comes to you and says a terrible derogatory word, I don't want to say it in this court. I don't know why I can't even get myself to.
Don't,
But,
yeah, please don't.
F boy, which is sexual in nature, which is demeaning in nature, said that to him first.
Mhm.
I think that's consenting to not whatever's going to come back. Obviously, it's not consenting to a punch in the face, but I think it's consenting to a word coming back at you.
How about to the shooting of the gun? Is that playing at all? Didn't he shoot a gun? Your client?
He has property where shooting a gun is appropriate and legal and fine. And he shoots his gun on his property. I think the petitioner alleged that he was shooting it.
Right after
To
saying
send a
certain
message.
words, yeah.
Right.
Maybe, I'm not
And while also saying this word, yeah, according that is the allegation in the petition. That he said the word, then he went and did the shooting outside and continued to say the word.
That's the facts. That's what's up with that.
Okay.
Okay. Anything else for us? Ms. Siegel, I want to actually commend you. I know we've worked you over pretty well here, but I want to commend you for making a very effective argument for an extremely unsympathetic client. So you've done a nice job.
I'm used to that. Your Honors, I want to thank Your Honors for demonstrating such a thorough review of the materials. If I ever had doubted it in the past, I would never doubt it now after this. Thank you so much.
Thank you very much. We appreciate your appearance on both matters here today. And the case is submitted. Item 9, consolidated cases, docket numbers 376001 and 376002, in re C.K. Anderson minor. Mr. Ambrose.
Good afternoon. It's Ronald Ambrose, appearing on behalf of Mother in this case. This is essentially a Hicks-Brown type of an issue concerning reasonable accommodations for my client. My client contends that there were not reasonable accommodations made in this case. 3 years into the case, the agency that was involved, Samaritas, was removed from the case because they were not providing reasonable accommodations for my client, who had an IQ of 60. It's considered extremely low, and they call it, well, it was just the lowest you can really get when you rate them. There were efforts made, but I don't think there were enough efforts to be considered reasonable. There wasn't any expert testimony from the government suggesting that these accommodations that were provided to my client were enough to have her understand what was being required of her. So primarily, that's the ultimate issue in the case, and without the reasonable accommodations, you really can't get into whether or not there was a statutory ground for removal, or even get into the best interest issue. I would even suggest that the best interest issue, that there was a bond there, and the children certainly called my client mom, and I think that was undisputed. But you have any questions?
Any questions for Mr. Ambrose on this one? I don't think so.
Appreciate
So can we conclude that one, because you're also on the next item?
Oh, they're all the same argument.
Okay. I'm referring to item 9.
Yes.
Are we done? Are you done there?
Yes.
Okay. So item 9 is submitted, which brings us to item 10. So you can stay right there, obviously. This will take me a moment because of consolidated cases, and there are 5 docket numbers. So bear with me. Item 10, docket numbers 377-671, 377-673, 377-674, 377-675, and 377-677 in Ray Austin minors, in Ray MJ Austin Jr. minor, in Ray D.E. Jones minor.
And it's Ronald Ambrose again, appearing on behalf of mother in these cases. I previously provided my arguments on why this case should be reversed. All we're asking is on reversal is reasonable accommodations to be provided.
Any questions?
No.
Okay, very good. That brings us to, thank you for appearing, Mr. Ambrose. We appreciate it. Our last two items of the day, which will be submitted on the briefs. Item 11, docket number 365745, City of East Point versus Jaja Michelle Soward, will be submitted on the briefs. Item 12, docket number 372878, City of Detroit versus Penn State Energy LLC, will be submitted on the briefs. With that, we are I'm sorry. No one's endorsed.
I don't see anyone endorsed.
So who checked in for one of the items? Okay. I think understood. Okay. Thank you for showing
That's
up.
appreciated.
Yeah, absolutely. Okay, with that, we are concluded today. We'll be in recess until 10 o'clock tomorrow morning.